Hi, everyone. My name is Helen Hapner, and I am an associate in the firm's litigation and employment groups. My presentation today is going to talk about some recent developments in federal law. To start with, I'm going to cover some of the Biden administration's employment law priorities and executive orders and some of the implications for employers. First, let's talk about non-competes. During President Biden's campaign, he promised to sharply limit the use of non-compete agreements. On July 9th, President Biden signed the executive order on promoting competition in the American economy. The executive order directs the Federal Trade Commission to ban or limit those non-compete agreements and other clauses in agreements that may unfairly limit worker mobility. Specifically, the order is aimed at regulating the unfair use of non-compete clauses and other restrictive covenants, such as non-solicitation and no-hire agreements. It does not ask the FTC to limit those restrictive covenants that might be understood as fair or as reasonably necessary to protect trade secrets. The stated intent of the executive order is to increase competition and economic growth by making it easier for workers to change jobs, and in so doing, to allow workers to more easily seek higher wages, better benefits, and better working conditions. As you may remember, in 2020, Washington implemented comprehensive legislation limiting the use of non-compete agreements by employers. Non-competes are enforceable only for employees and independent contractors making over a certain salary threshold in Washington, and they are limited in a number of other ways as well. However, non-competes are not altogether prohibited under Washington law. It is unclear what the impact of the executive order will be, as it does not detail how or when the FTC should take action to restrict non-competes. It is unclear whether the FTC might issue a full ban or impose some type of standard on restrictive covenants, or if it will ban these types of agreements only for workers earning under a certain salary or hourly wage threshold. It could take a long time, months or even years, for the FTC to implement rules under the executive order. Employers should be aware of the potential for changes in non-compete law and review the use of non-competes and other restrictive covenants, keeping in mind the potential for further restrictions on their use. Another priority of the Biden administration is strengthening labor organizing and collective bargaining. President Biden has signed the proposed legislation called Protecting the Right to Organize Act, or the PRO Act, which would significantly strengthen the ability of unions to organize in several ways. First, it would invalidate so-called right to work laws, which allow employees in certain states to opt out of unions and not pay dues. Under the act, unions could collect dues from even those workers who opt out. In spite of such laws, Washington state does not have a right to work law. The act would also protect union elections in a number of ways, including by providing for election locations off company property. The act also bans captive audience meetings, which are company-sponsored meetings with mandatory attendance that might be used to lobby against an attempt to unionize. The act provides for mandated alternative dispute resolution and contract negotiations between new unions and companies in the event that an agreement about the labor contract is not reached within 90 days. The act makes it an unfair labor practice to do a variety of things, including permanently replacing strikers or penalizing employees for participating in or supporting the strike. And it also makes it an unfair labor practice for employers to impose class action waivers on employees. The act adds monetary penalties in an amount of up to 6 figures as remedies for unfair labor practices. And it also allows personal liability for executives whose companies engage in unfair labor practices. The PRO Act has been passed in the House, but not in the Senate. This month, the House Education and Labor Committee included budgetary provisions of the PRO Act in the federal budget through a process known as budget reconciliation. The provisions in the PRO Act with budget implications include those that we just discussed, those creating monetary penalties for companies that engage in unfair labor practices under the act, which would be a significant change in policy. Another way in which President Biden has signaled his administration's support for worker organizing is the Task Force on Worker Organizing and Empowerment, which was established through executive order. This task force seeks to promote the Biden administration's policy of support for worker power, worker organizing, and collective bargaining. In announcing the task force, the Biden administration connected the decline of union membership with certain economic and social problems, such as economic inequality, lack of a living wage, and the shrinking middle class. The task force is chaired by Vice President Harris and vice-chaired by Labor Secretary Marty Walsh. It also includes more than 20 cabinet members and heads of other federal agencies. This representation gives you an idea of just how important this task force is to the Biden administration. The task force is charged with identifying existing policies that could be used to promote worker power in areas of the country with hostile labor laws. And it is charged with promoting the power of marginalized workers and facilitating worker organizing in different sectors of the economy. In addition, the task force is directed to identify statutory, regulatory, or other changes that would make policies and programs a more effective means of supporting worker organizing and collective bargaining. The takeaway here for employers is that strengthening and promoting union organizing and collective bargaining are a major priority for the Biden administration. Employers who may be impacted should continue to monitor developments in federal legislation on these issues. Another important priority for the Biden administration is addressing discrimination based on gender identity and sexual orientation. On January 20th, 2021, the day he was inaugurated, President Biden issued an executive order aimed at preventing and combating discrimination on the basis of gender identity and sexual orientation. In Bostock v. Clayton County, an important recent Supreme Court decision, the court held that Title VII's prohibition on employment discrimination because of sex prohibits discrimination based on sexual orientation and gender identity. President Biden's executive order applies the Bostock holding to federal agencies, directing them to enforce a prohibition on discrimination on the basis of sexual orientation in different contexts, not just employment. Additionally, the executive order requires the heads of federal agencies to review all existing regulations and guidance to ensure that they are consistent in their protection on the basis of sexual orientation and gender identity. The Biden administration also strongly supports the Equality Act, which has passed the House of Representatives but faces an uncertain future in the Senate. The Equality Act would amend Title VII, as well as other federal civil rights laws, to prohibit discrimination based on sexual orientation and gender identity. It would also prohibit discrimination based on pregnancy or sex stereotypes and sex characteristics. Notably, the Act specifically excludes the use of the Religious Freedom Restoration Act, or RFRA, as a defense to a claim of discrimination. RFRA has been successfully used in some civil rights litigation in other states as a defense to a claim of discrimination based on sexual orientation. So this is a notable exclusion. It is also worth pointing out here that the Washington Law Against Discrimination unequivocally prohibits discrimination on the basis of sexual orientation and gender expression or identity. Nevertheless, employers should be aware of the Bostock decision and other developments in federal civil rights legislation and ensure that their policies and practices are consistent. Next, we are going to review a noteworthy NLRB case focusing on an employer's social media policy for its employees. In the Medic Ambulance Services case, the NLRB was asked on appeal to review, among other things, provisions in an employer's social media policy that restricted employee communications on social media. The provisions of this social media policy included restrictions on the use of the employer's name or logo on social media and employee opinion posts. The social media policy also prohibited posting photos of coworkers without written consent, and it prohibited inappropriate communications on social media, including disparaging the employer or other employees. Additionally, the social media policy prohibited sharing employee compensation information or sharing any proprietary or confidential information of the employer or coworkers. This social media policy was challenged under Section 8A1 of the National Labor Relations Act, which applies to many private sector employers. Section 8A1 of the Act makes it an unfair labor practice for an employer to interfere with the rights protected by Section 7 of the Act. Section 7 guarantees employees certain rights, including the right to self-organization, the right to form or join labor organizations, and the right to engage in collective bargaining. During the Obama administration, in determining whether a workplace rule violated the NLRA, the National Labor Relations Board looked to whether an employee might reasonably construe a workplace rule as prohibiting activities protected under Section 7 of the Act. However, when the makeup of the board shifted during the Trump administration, the board overruled the reasonably construed standard in the 2017 Boeing decision and instead adopted a standard aimed at striking a balance between, on the one hand, the employer's stated legitimate business justification for the rule, and then on the other hand, the impact of that rule on an employee's NLRA rights. In Medic Ambulance, the board applied this balancing test and reversed an administrative law judge's findings that the employer's social media policy violated the act. The National Labor Relations Board determined that the rules prohibiting the sharing of employee compensation information on social media and prohibiting the use of social media to disparage the employer or other employees were not unlawful. This is a positive decision for employers with similar social media policies or restrictions. However, the Medic Ambulance decision is not necessarily settled law. The makeup of the NLRB has recently changed following the inauguration of President Biden. It is possible, therefore, that the NLRB may return to the reasonably construed standard of the Obama administration, or it may implement a different review standard altogether. The takeaway here is that as we increasingly rely on social media as a primary form of communication, it might be appropriate for employers to consider implementing a clear social media policy with reference to employees' rights protected under the NLRA and a changing National Labor Relations Board analysis of what the Act requires and what the Act protects. Thank you so much for your time and attention today. I hope you found this helpful. As you can see, my contact information is provided here. Please feel free to reach out to me with any questions about this presentation.